Okay, next let's practice. Yeah, I said that that we would do some little practice. Okay, so you can see more or less the type of exercise, and I want you to participate. Okay, so if you have some paper and a pencil or a pen, I would like you to write down your answers. Okay, because you're going to need them. Okay, maybe some words that you learn now. I want you to write them down, because then you will see how many words you have learned. Now this is, well, I don't know how long we're going to take. Okay, maybe this is going to be half an hour or so. But just let me know if you need to go. All right. So there is there are some exercises that are well, that test vocabulary, but they do not give you a context. I will give you an example. So we have 4 words, and you have to choose the one that does not correspond to the group. Yeah, in this one we have shares, sue, proceedings, and litigation. So make a guess. I don't know if you know the meaning of all of them, but make a guess. Which one do you think does not belong to this group of words? Yeah, you can write it there. Just go ahead and write it, Laura. Shares. Okay, yeah, shares. The other words, sue, proceedings, and litigation, they belong to civil law. Yeah, to the areas of civil law. Let's do another one. Tort, damages, consideration, negligence. Which one does not correspond? Consideration. Okay, consideration does not belong. Okay, we have tort, damages, and negligence, and these are words from the law of tort. Yeah, that we already said that it has to do with liability. One more. Recitals, parties, definitions, resolution. Which one does not belong? Definitions, resolution. You doubt? Okay, so these are the parts of a contract. No, not the parts of. Yeah, well, yeah, the parts of a contract. Recitals. Oh my goodness, we just need someone that says parties. Okay, well, this one was not the best. Okay, we have in a contract, you can find the recitals section, the parties, and the definitions. Yeah, resolution is not a word that you can find there. Okay, in section 4, we're not going to do this one because it's going to take a long time. Okay, now there are more exercises about use of English. Yeah, that test grammar and they test prepositions. So I'm going to show you first one of grammar. In the foundation exam, you have some sentences, it's usually 5, yes, and you have these sentences, and they tell you that there is a mistake. It's either a word that is extra, or a word that should not be there, or a word that is wrong. And maybe you have to replace it either with something else, or something is wrong with the word. I'm not going to tell you now. So if you look at sentence number 7, what's wrong in this sentence? Just write the word in the chat. Proof. Okay, proof. Yeah, so proofs is wrong, right? It has an extra S, and the correct word is proof. Okay, what about 8? Please inform me of any amendments you want to do to the contract. Do you see anything wrong? You want me to do? Well, but there's only one word. Sandra, you're gonna go and circle everything in the sentence. Yeah, you only have to mention one word that is wrong and that you would need to change. And this is do. Okay? It is do. Now the correct word in here would be to make. Yeah, because you make amendments. Yeah, you make amendments. In sentence 9, they settled the dispute out of the court. What's wrong in this one? The. Okay, the. Correct. They settled the dispute out of court. I would have needed to ask you which the, okay, because we have two, the dispute and the court. All right, but it's the second the. Well done. Another one in foundation. They give you 2 pairs of sentences. They're very similar, but their only difference is a preposition. Well, one of the prepositions, okay, because some of them have more than one. So in this pair, in 10, I act on behalf of the defendant. I act on behalf for the defendant. Can you write A or B? Which one you think is wrong? Well, actually, you have to mark the one that is correct. So which one is correct? I act on behalf of the defendant, or I act on behalf for the defendant? Okay, so Laura says A. Yeah, this is the correct one. Well done. All right. Now, we'll look at an exercise from TOLES Higher about prepositions. We have here an extract of an agreement to hire. Again, this clause is called limitation of liability. Yeah, limitation of responsibility. Now they give you a short text, and you need to put the prepositions that they give you in the correct place. All right. So I'm going to read the text, and let's see how many you get correct. This is just for fun, okay? I'm not judging your English right now. Yeah, I just want to know if you would do this correctly or not. So you can go ahead and do like 12. I'm not gonna say like 12C or 13C, 14C, 15C. Okay, so you tell me only the letter that you think the preposition is. We have the company shall be relieved all liability for costs and obligations incurred by the hirer and any other party. The event that fulfillment the company's obligation. This contract is frustrated. It doesn't really matter if you don't understand now what this is. Okay, just a matter of, knowing which prepositions go in which place. So I give you a minute, okay? I give you a minute so that you can write your 12 and then your answer, 13 answer. Okay, or just do like Sandra says, DCBA. Okay, let's look at the first one. You said the first one is D. Well, we have all of them here. Okay, so the company shall be relieved of all liability. Okay, so D, that's correct, Sandra. And any other party in, that's C, well done. Fulfillment of, Wait, this one is of. Oh, so the first one was off. You said D. Sorry, I got confused. You said D of. I'm confused. You said D, C, B. Okay, I get this wrong. Well, fulfillment of. The preposition was not even there. Sorry, that's my fault. Oh, that's so embarrassing. Okay, this one should have said of. Again, sorry about that. The company's obligations under. Okay, that is A. Well, sorry about that, Sandra. This answer was not even in the options. But well done. Well done. Then there is another exercise that tests vocabulary, but this time within context. So we have 3 words in here: to retire, strike, and resign. Yeah, all these sentences are about employment law. But they're words that you should know. I mean, if you studied English recently, I say recently because you may remember better. Okay, but these are words that you usually learn at school. So let me know again. Let me know again about your answers. We have to from your job means to inform your employer that you want to terminate your contract of employment. Okay, Sandra, this is to resign. Yeah, well done. The age at which people usually retire from work is 65 years old. Okay. The employees were so unhappy that they decided to, yeah, I didn't include this one, to strike until the managers agreed to pay more. Yeah, well done, Sandra. Okay. This one is from hire. Yeah, and again, it's a short sentence where you can just choose one of these 4 options. According to contract law, an offer can end due to of time. This means that too much time has passed since the offer was made. Lapse of time. Okay, well done. Lapse of time. Okay, now this is again another text that you have some options. Yeah, I'm just going to pass this one. Okay, now there is in the hire, in the listening part, this is something that they don't do in Cambridge, okay? But they give you a long text with some gaps that you have to fill in. The thing is, you're going to hear the text, but sometimes it's not so easy. Yeah, because really you have to spell the word correctly, and sometimes that's not so easy. So I'm going to read this extract, and you have to tell me which word I have said. Yeah, apparently this is easy, but the text is very long, really. So let me get the text. Where am I? Hold on, 53. Oh, there you go. Many employees are now taking legal action against employers on the ground that they have been discriminated against because nationality or religion. Who got the word? Did you get the word? Grounds, okay. On the grounds that they have been discriminated against. Yeah, the grounds are the reasons why someone starts a claim. Well done. Okay, then remember I told you about an area of law that not many people know about, and it's particular of England and the United States. Remember? What is this area of law? Tort, okay. So the law of tort in here exist in order to compensate a person who has suffered as a result of a civil wrong. Lawyers divide torts into two heads. Yeah, heads are categories. And let's see if you know this vocabulary. I'm just going to test you now. You should know this vocabulary in Spanish. Okay, if you know it in Spanish, just tell me. It doesn't matter if you don't know the word exactly in English. So negligence, which is a breach of the duty of care. To land, which involves entering someone's land without permission. Do you know this word? If you enter someone's land without permission. If you don't know what, I just skip to the next one. Trespass. Okay, nice, Laura. Trespass to land. Well done. I thought you wouldn't know. This is trespass to land. Okay, the next one, that is interfering with someone's enjoyment of their land or house. Yeah, it involves, for example, when you have noisy neighbors and you can make a claim against your neighbors because you cannot enjoy the peace in your house. Any idea what this is called? Nuisance. Okay, Laura. I'm very surprised that you know this vocabulary. This is a very good sign, though. And the last one is the tort of publishing or saying something that damages a person's reputation. I have a course in university. Okay, that's cheating. No, that's good. I'm glad. So what is the last one? You publish or you say something that damages a person's reputation. Any idea? Defamation. Okay, and then depending if it's written or if it's spoken, it's called libel or slander. This is just extra information. Well done. Okay, well, up to here, do you find it easy? Do you find it difficult? Do you find it okay? Do you think you could take a test like this without studying anything? What do you think? It's difficult. Okay, so even if you knew these words which are from the advanced exam, yeah, even if you knew this, you still think it's difficult. And this is only like little extracts from the exam. You cannot know these words without studying them. That's right. I mean, there's no other way. It's a matter of reading a lot, reading about contracts, reading about litigation a lot, and you can only learn this vocabulary if you use it. Yeah, it's very, very important to do that. Okay, something else. Okay, let's continue. We have one other part, yeah, that is about meaning, corrections, and explanations. So, well, we're just going to do like one little exercise of each. Yeah, one for foundation, one for higher, and one for advanced. Yeah, it should take us around 5 minutes. Are you in a rush or something? Because I said this would be about an hour, but it's 8:30 already. Do you have to go, or can I keep on doing this? I have to go very soon. Yeah, well, you told me that you have a kid, so I also have a baby. I don't know if you can hear him, because sometimes he screams very loud, and I really don't know if you can hear him. Okay, so we have here an extract from a contract of employment, and some words are underlined, and they give you some synonyms. Sometimes, and other times they just give you a little definition. Okay, so this one says working hours. You will be required to work additional hours from time to time to enable you to carry out your duties properly. You should not be entitled to receive any additional remuneration for work outside of your normal hours. I just read really badly because I had the numbers and I couldn't read everything. So you have here the meanings or some expressions that match these words. We have the right to do something extra or more than normal, over the limit of something, do, perform, and payment. So if you can take a minute to write your answers, or just go one by one. So just go one by one. What is the synonym of additional? B, okay, so extra, more than normal. Okay, what is the synonym of to carry out? To do or to perform. Okay, D, well done. Entitled. Entitled means you have the right to do something. Okay, Laura. Remuneration. E, payment. That's right. And last one, outside. Outside of. Okay, C, over the limit of something. All right, well done. Okay. Now, we're going to look at a part of higher, which is letter writing. Yeah, you usually have very long letters, okay, but I just got a little extracts. So they give you a letter with some words underlined, and you need to give a correct alternative. Okay, so in this one it says, "Dear Mrs. Diana, I'm worried about the process of using the civil court to start off a legal process. Should I prosecute the other party? Sincerely, Emily." So the words that are underlined are not used in a proper way. Would you be able to tell me why this Mrs. Diana is wrong? What's the way to address someone in a letter without Mrs.? Okay, so if it's an informal letter, yeah, maybe this lawyer is your friend. Okay, so if she's your friend, you would say, "Dear Diana." You're right. But what if she's not your friend? What if she's your lawyer and you're talking to your lawyer and you want to be respectful? So if you want to say Mrs., yeah, after Mrs., we use the last name, not the first name. Yeah, so it would be something like, "Dear Mrs. Hopkins." Yeah, if this is her last name, we would say, "Dear Mrs. Hopkins." Now, there's a lot of controversy with Mrs. Because you can say Miss or Mrs. depending if she's married, if she's not. Yeah, but this is a whole other issue that we're not going to look into right now. Now, the next thing you need to change is using the civil court to start off a legal process. Yeah, this is an explanation of what you want to say. And the alternative would be either a word or an expression that is shorter. Can you think of any? Sewing, okay. I'm worried about the process of sewing. Yeah, but sewing is not a process. Now, I just tell you now, instead of to prosecute, because prosecute is a verb that you would use in a criminal court, not in a civil court. Instead of this, you can say to sue. Yeah, should I sue the other party? This one, yes. But then the other one, using the civil court to start off a legal process. Yeah, a synonym of this, or another way to say this, would be to issue a claim. You can issue a claim, you can start proceedings, you can make a claim. There are about 5 ways of saying the same thing. Okay, so this one really would have multiple possible answers. And the last one, should I sue the other party? All right. Now, the advanced one. And this is the last exercise we're going to look at. And it's the most difficult. Yeah, this is an extract of another contract. Yeah, a contract for the sale of goods. And this is cancellation. I have to go, please send me the recording. Okay, I will send it to you. I will send it to you, Laura. Bye-bye. Sandra, sorry. Bye-bye. All right. So Laura, I think it's you. Yeah, it's you and Paula. I don't know if Paula is still there or if she fell asleep. So we have this contract for the sale of goods. And this is a cancellation provision. It says any purchase order issued by the purchaser or any part of the purchase order may be cancelled by the purchaser at any time before title to the goods passes to the purchaser. This is a contract, yeah? How beautiful is a contract? With a very, very long sentence. Yeah, typical legal English. Now, what you have to do in this exercise is to try to explain with your own words what this clause means. Yeah? And I'm going to give you a challenge. Okay? The challenge is to explain with, I wrote my option here, with 15 words. I think I lost it, but I think I could describe all this in 15 words. Laura, do you think you can do this? And Paula as well. Yeah, you can also you can also do this if you think you can. Let's see. Well, since it's only us three, maybe you can talk, Laura. Would you like to talk? And tell me? I'd rather not. You're so polite. That was very polite, Laura. It's okay. You don't have to talk. You're not very sure about this one. Okay. If it were easier, maybe you would talk. But let's see. It's just a challenge for fun. Is this a typical question? Yes, this is like one of the most important questions. In fact, you have a very, see, I can even show you. I mean, I have the book for the advanced tests in here. I can show you what it looks like. There's a question that is number 59, and you have 3 clauses of a contract. Yeah, like this, like the whole page. And then, just for you to have an idea of what this is like, they give you 4 pages to answer the question. So they really want you to explain everything in detail. Yeah, and this is worth 75 points. Yeah, it's 75 out of 300. Yes, but still, this is a very typical question. Yeah, describing what goes on. You have to explain them with informal words. Yes, you have to explain it, to explain this as if you were doing it for a friend. In fact, I tell you, I tell you the question, what it says. It says, look at the following contract clauses. Explain the meaning of each clause in a way that will help a friend who speaks English but who is not a lawyer to understand that clause. Yeah, you should use a modern, plain English style and briefly explain any legal terminology. So if there is any terminology that you may think some person that doesn't know anything about legal English or about law in general wouldn't know, you have to explain that. The advanced is very difficult. Well, Thing is to try. I mean, if you think about it, it is more difficult to explain with advanced words than to explain with plain language. Do you want to try? And I chose a very easy class. Yeah, because there were some that were quite difficult. No idea? Paula, you should try. Okay, well, what does it mean? Just try to read it once for yourself, and maybe you can, I don't know, you can tell me. Well, first thing, do you know what it means? Because maybe that's a problem. Maybe I'm just going too fast. Do you think that the problem in here is the vocabulary? I'm sure that you know the words in here. So let's see, a purchase order. It's just an order. I mean, you buy something, and then this is an order. The purchaser. What's another way to refer to a purchaser? This is someone who purchases something. This is a buyer. Yes, a buyer. Then we have a part of the purchase order may be cancelled by the purchaser at any time before title to the goods passes to the purchaser. So a purchaser or the buyer can cancel the order before they have the goods. Okay, I see that you wrote something, Laura. You can change or cancel your what? Okay, so you can change or cancel what you bought or the condition of the purchase whenever you want until you actually own the good. Okay. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. I said 15. You have like 25. So you can still reduce this to, you can change, you can change or cancel your order, or you can change or cancel what you bought before you own the good. And this is even less words. But very well done. Okay, you tried. Very well done. This was my answer. Okay, this clause deals with cancellation. Yeah, that's just a clarification. The buyer has the right to cancel an order fully or partially before receiving it. Yeah, so you can cancel it fully or partially. Yeah, you know, this is something typical. Once you see the answer, you say, oh, of course, I could have said that. All right, well, this is all. Yeah, this is all that I had for today. That's all, folks.